At this time, court calls State of Wisconsin v. Stephen Avery, case number 05CF381. We're here this morning for a continuation of a trial in this matter. Will the parties state their appearances for the record, please?
Good morning, Judge. The state appears by Calumet County District Attorney Ken Krabs, Assistant Attorney General Tom Fallon, and Assistant District Attorney Norm Gahn, appearing as special prosecutors.
Good morning. Stephen Avery is present. Jerome Buting and Dean Strang also present on his behalf.
The first item of business today is for the court to issue its decision on 3 outstanding motions. The court has already heard argument on these motions. I'm ready to issue the decisions at this time. The first motion the court will address is a renewal from the defence of its fair testing motion. That is, a motion was filed pre-trial by the defence last summer asking for permission to have the observer present while the Wisconsin State Crime Lab was performing analysis of various pieces of evidence. The defence counsel argues that the defendant in this case was prejudiced because the defence was not permitted to have an observer present while DNA testing was conducted of a bullet by Sherry Culhane. Miss Culhane testified that during the testing process some of her DNA made its way onto the control sample that should not have contained anyone's DNA. She believes it happened as a result of saliva that came from her mouth while she was speaking to observers within the lab who were being trained at the time. Miss Culhane testified that there was no evidence of contamination in the test of the extract from the bullet itself, which is found to contain Teresa Hallback's DNA. The defence argues that this account given by Miss Culhane demonstrates that defence need to have an observer present during testing. The observer might have suggested splitting the extract from the bullet as a control, before the remainder of the test was completed, in order to determine whether Teresa Hallback's DNA was in fact on the bullet, or somehow found its way into the abstract through contamination. An observer may also have seen, argues the defence, how Teresa Hallback's DNA may have gotten into the extract if it had happened through contamination. As a remedy, the defendant asks that the court suppresses the test results, or in the alternative, if suppression is not granted, instruct the jury that the state resisted the defence request to observe the testing process. The state testing totally consumed the sample, and the state withheld the crime lab's contamination log until it was specifically requested by the defendant. Both parties acknowledge in their argument that the test, which the court must apply, is that set forth in the United States Supreme Court case of Arizona v. Youngblood, that is, unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process in law. The issue boils down, then, to whether or not the state was guilty of bad faith in this matter. The evidence that the defence cites as evidence of bad faith on behalf of the state is the following. First of all, the state resisted the defendant's initial request to observe the testing. Second, the state did not disclose the crime lab's contamination log history to the defence at the time of original fair testing motion. The argument is that earlier disclosure may have allowed the defence to succeed in its earlier motion. Third, that the state did not provide a copy of the contamination log as part of the defendant's original general discovery request. Fourth, the defendant expressed its concern about contamination at an earlier stage in the proceedings, and Miss Culhane's testimony demonstrated that the contamination occurred. Fifth, the defendant personally expressed his concern about being framed at an early stage in the trial. And sixth, there is no clean sample left for the defendant to test because the extract that was found to contain the victim's DNA may have already been contaminated, and there is no sufficient DNA left on the bullet to independently test. The court concludes that those facts do not demonstrate a finding of bad faith on the part of any representatives of the state. With respect to the first part of the defendant's request, that the state resisted its request to observe the testing, the law in Wisconsin is that the state had a right to resist that request. Relevant are Wisconsin Statute Section 17679(1), as interpreted in the Court of Appeals case of State v. Franczak. Franczak, a 2002 reported decision. The court in that case summarised the law under the statute as follows. All evidence, information and analysis of evidence submitted to the crime lab by law enforcement is privileged and therefore is off limits to the defendant prior to trial. The same is true to the analysis of such evidence by the crime lab. This privilege also bars any effort by a defendant to examine crime lab personnel as witnesses prior to trial. There is an exception with respect to such evidence, as is subject to discovery under section 97123, and in fact, discovery was exercised here, and the state did present materials. The point is, there's nothing improper about the state's initial resistance to the defence request for fair testing. It's authorised under the statute. The second state argument is that the state did not timely disclose the contamination log history to the defence, or the court's original decision might have been different because the defence argument for observation would have been stronger. The court would not have ruled differently on the original motion even if it had known the existence of the contamination log earlier. Frankly, the court is relieved to know that such a log is kept and an aid to defendants who are able to make use of it in cross-examination, as the defendant did in this case. The court believes it is far preferable to have a contamination log than if the crime lab was hiding its mistakes. I will also note there is no evidence to suggest the contamination log demonstrates any fraud on the part of the crime lab in its history, as the defence referred to in other state crime labs as part of its original argument. The defence also argues that the state did not provide a copy of a contamination log as part of the defendant's general discovery request. The court wasn't really presented with information to suggest whether or not the contamination log would have been within the scope of the original request made by the defence. However, it appears that the state did provide a copy of the contamination log to the defendant upon specific request for the log, and the court believes that the defence was able to effectively use information from the contamination log in its cross-examination of Miss Culhane. That is, the court doesn't believe there was any prejudice to the defence in the conduct of its case. The fourth argument, advanced by the defendant, is that the defence expressed concern for contamination, and in this case contamination admittedly occurred as Miss Culhane testified. The court finds that despite that expressed concern on the part of the defence, doesn't change the law in this area, that the state is simply not required to permit an observer at the crime lab. The defence also argues that the defendant himself personally expressed concern about being framed earlier in this case. The court understands that in fact was the case here, but the court also understands that the defendant's claim is that he was being framed by members of County Sheriff's Department and not members of the crime lab. I think it's worth noting in this case that it was Miss Culhane's testing of the DNA in the 1985 case that in fact led to the defendant's exoneration. The court is not aware of any allegations that the crime lab was a party to any frame-up here, and the court finds no reason to believe that this was the case. The last argument was there's no clean sample left to test. As well, there is an abstract of the blood evidence. That abstract may have been already contaminated. There is no indication here that the operator, Miss Culhane, used more of the sample than was necessary. She used her best judgment in testing the bullet as she did. She testified that there was nothing visible on the bullet and she felt she had to take an extract from the bullet in order to get enough of a sample to test. The court can't find anything wrong with that, which would constitute in any fashion bad faith on the part of the state. The bottom line is Miss Culhane did somehow contaminate the control sample in the course of the testing process, and she disclosed that contamination. She followed protocol in asking for exception. Her mistake was disclosed to the defence in a timely manner as part of discovery, and the defendant skillfully elicited her testimony about the mistake in cross-examination. The court does not believe that any bad faith has been shown, or that the defendant has been unfairly prejudiced in any manner, and for that reason that motion is denied. The next motion renewed by the defence is motion to suppress evidence from multiple searches. This motion was renewed outside the presence of a jury during the trial on February 23rd. At that time, the defence renewed its motion to suppress evidence based on illegal searches, which was initially denied by the court in a 20-page written decision on December 12th of last year. Defence counsel cited 3 separate bases for renewal of the motion at this time, based on evidence that was introduced up till February 23rd. First, the defendant claims that the testimony of Special Agent Fassbender and other officers who participated in the execution of multiple-day search is not consistent with the facts which formed the basis for the court's original ruling. Specifically, the defendant characterised the initial entries as prohibited warm-up searches, which were not constitutionally permitted. In the court's view, the evidence introduced at trial was consistent with the court's earlier understanding of the basis for the various entries into the trailer and garage that were occupied by the defendant. The court is not going to repeat here its earlier findings or conclusions, other than to note that the evidence supports the court's prior understanding of the circumstances under which the entries to the defendant's trailer and garage were made. The fact that there was admittedly multiple entries raises a number of interesting legal issues of apparent first impression of the state of Wisconsin, but the court believes it's addressed those issues and has written their decision, and the evidence introduced does not change the factual assumptions that were part of that decision. The defendant's second argument is that the facts introduced gave new life to the defendant's Frank's motion, specifically the emphasis by law enforcement in the early stages of the search, treating the case as a missing persons case. The defence alleges undercut the representation made in the affidavit for the initial search warrant by Mr. Wiegert. Mr. Wiegert's specific representations in the affidavit for the warrant were the following. Your client believes that based on Teresa's lack of contact with her employer and family members, her vehicle being abandoned at Avery Auto Salvage Yard, that Teresa Hallback is a victim of a crime, including, but not limited to, homicide, sexual assault, kidnapping, false imprisonment, and theft. Essentially, the court understands that the defence argument to be that the state is not permitted to suspect the worst, but hope for the best. The court does not agree. Given the facts available to law enforcement, the authorities at the time, primarily the lack of conduct or contact with Teresa Hallback for a number of days, and the circumstances surrounding the discovery of her vehicle, even before anyone's blood was found inside the vehicle, there was more than prohibitive cause to suspect serious foul play, in the form of the crimes listed in the affidavit. It's not inconsistent in those circumstances for law enforcement personnel to hope that their legitimate suspicions are wrong and that there might be some explanation that would be consistent with Teresa Hallback still being alive. There's nothing unreasonable about what the state did, or what the state gave as basis in the affidavit for the search warrant. The information known to the state at the time, which reflected in the search warrant, provides adequate probable cause for its issuance. The defendant's separate argument is that the state waited too long to commence its search of the burn pit area behind the defendant's garage where the victim's bone fragments were found. As the court understands the argument, it's different from the challenges to the searches of the trailer and the garage because the claim is not based on improper multiple searches, but rather on an improper delay conducting the search at the time after the possession of the defendant's living quarters should have been turned back to him. The court finds nothing improper about the timing of the search in this case. Section 968(15) requires that the search warrant be executed and returned within 5 days. The search of the burn pit commenced before that time period expired. The defence makes much of the fact that the searchers initially refrained from starting the search because of the presence of the defendant's dog, and that's not a valid reason for not starting the search earlier. Even if the dog appeared to be dangerous, the court agrees that the presence of a dog alone would not excuse the timing of the search in this case. However, what does excuse it are a number of factors. First, the court noted that the search was commenced within the 5-day limit. Second, law enforcement personnel had a very large area to search under the warrant, that is, the entire Avery Auto Salvage Yard, and they did not artificially delay in any way their search of the burn pit. Third, and most significant, the significance of the burn pit site was not apparent until what appeared to be human remains were discovered there. Once that discovery was made, the authorities worked promptly to collect the evidence. There was nothing unreasonable about the search of the burn pit. For these reasons, the defence renewed motion to suppress evidence based on unlawful searches is likewise denied. Third motion that the court addresses this morning is a defence motion to dismiss all charges against the defendant at the close of the state's case. The standard that the court is to apply in this situation has been stated as follows. The test is whether, considering the state's evidence in the most favourable light and the evidence adduced, believed and rationally considered, is sufficient to prove that the defendant's guilt beyond a reasonable doubt. That is, the court has to look at the evidence in a light most favourable to the state and ask itself whether a reasonable jury could find that defendant is guilty beyond a reasonable doubt. In this case, the defendant moved to dismiss all charges, but did not present specific argument on the homicide, mutilation of a corpse and possession of a firearms charges. The court is not going to summarise all evidence here, but it concludes that the state has introduced evidence which, if believed by the jury, would be sufficient to prove the defendant's guilt beyond a reasonable doubt. on these 3 particular charges. The argument advanced most strenuously by the defendant is that the evidence introduced by the state, even if believed by the jury, would not be sufficient to sustain a guilty verdict on the false imprisonment charge. The elements the state must prove on the false imprisonment charge are as following. 1. The defendant confined or restrained Fraser Hallback during her lifetime. 2. The defendant confined or restrained Fraser Hallback intentionally. 3. Fraser Hallback was confined or restrained without her consent. 4. The defendant had no lawful authority to confine or restrain Fraser Hallback. 5. The defendant knew that Fraser Hallback did not consent and knew that he did not have lawful authority to confine or restrain her. The court understands the defence argument primarily to be that there is no evidence the defendant confined or restrained the victim in this case. The state introduced no direct proof of that particular element, but asserts that it has a circumstantial evidence case. The state points to evidence that the defendant used his sister's name in requesting the victim to come to his property. Bobby Dassey testified he saw Fraser Hallback heading towards the defendant's trailer after he observed her taking pictures of his mother's van and did not see her 3 to 4 minutes later when he looked again after taking a shower. The bullet fragment with the defendant's DNA was found on the floor of the garage. The state submits the evidence demonstrates that the victim was killed in the garage by 2 bullet wounds to the head. The state also argues the evidence demonstrates that the victim was forced involuntarily from the trailer to the garage, and that's the basis for the false imprisonment charge. The state does offer a plausible scenario for what happened, however that's not the standard that the court must apply. The evidence has to be sufficient to support the jury verdict of guilt. Beyond a reasonable doubt, the circumstantial evidence introduced by the state is, if believed by the jury, sufficient to sustain a guilty verdict on the other charges, but the court believes there is minimal evidence supporting the false imprisonment charge. Viewed most favourable to the state, there is a logical inference that the victim entered the defendant's trailer for some unspecified period of time, that she was killed by the defendant in his garage. There is no evidence from which a jury can determine the circumstances for how she went from the trailer to the garage. To conclude on the evidence presented, that she was forced there against her will would require speculation on the part of a jury. The court believes it's not coincidental that the defendant was not charged with false imprisonment until after the state received statements from Brendan Dassey. The fact alone would not prevent the state from pursuing a false imprisonment charge if there was other evidence to support the charge, but the record does not contain such other evidence. During the voir dire, a number of jurors indicated that they were at least somewhat familiar with the case against Brendan Dassey. To submit this charge to the jury would, the court believe, invite the jury to fill in the blanks, if you will, by what they might otherwise remember about allegations that have not been supported by evidence in this case. The court concludes there is not sufficient evidence in the record to support a jury finding of guilt beyond a reasonable doubt on the false imprisonment charge, and the court therefore grants the defendant's motion to dismiss the charge. Counsel, is there anything further before we bring in the jury?
I don't know what I need given the court's ruling, but if I do, I would move for entry of judgments of dismissal or acquittal on counts 4 of the second amended information.
Anything else from the state?
No.
Alright. The court will enter then a judgment of dismissal on that charge. I will indicate for the record that the court met with counsel before beginning today, and after discussion, I believe both parties and the court are in agreement that the court is going to individually voir dire the jurors because of the length of the trial, the extensive publicity that it's received, in order to make sure that the court's order has been adhered to in this case. And before doing that, I think it's beneficial to bring in the jurors briefly and let them know what's going on. I will also indicate, before we bring the jury in, that the court has spent a good deal of time in examining the circumstances under which the individual voir dire should take place, because the subject of the voir dire could include information about whether or not the jurors violated the court's order. The court does not believe that the voir dire should take place in the confines of this courtroom, which could easily be found to be somewhat intimidating to the jurors. It's very important in this case to make sure that the jurors express candour in giving their answers. In many cases, voir dire is conducted in chambers, without anyone else being present. But this case is different from any other cases because of the intense media coverage that it's received. The media is very interested in the case, and while the court believes there may be grounds to completely close individual voir dire, the court also believes that the consideration must be given to the interests of the media, and therefore I have decided that, although voir dire will take place in a small conference room that has very limited seating, The court is going to allow a media representative to be present during the questioning of the jurors. Earlier this morning, I instructed the media coordinator to contact the media folks who are here today and designate one of their members to be present. It will be the obligation of that member to report back to the other members of the media. Obviously, they will still be prohibited from disclosing the identity of any juror. If any action is required as a result of the answers given by the jurors, the court anticipates that would take place in open court, and not in the voir dire investigation in chambers. Anything further that either party would like to add to that before we bring in the jury?
Nothing. Nothing from the defence.
No, Judge.
All right. Let's call in the jurors at this time. You may be seated. Good morning, members of the jury. I can tell you that your first sitting in the jury box this morning will probably be the shortest sitting that you have had during the course of this trial. I indicated last Friday that because of the length of the trial and the concerns about exposures to the media coverage and other items, that it was entirely possible that the court would conduct some questioning of the jurors on an individual basis before the end of the trial in order to make sure that no improper information had found its way into the jury. Before we proceed further with the defence case this morning, that is what we're going to do. We're not going to conduct voir dire in this courtroom. It's going to be done in a small conference room, and you will be escorted by a sheriff deputy, one by one, to the conference room. So that questioning may take place. I only called you out here this morning so I could have a chance to tell you that. So at this time, I'm going to allow you to go back to the jury room, and in a few minutes, we'll begin individual questioning. Although you will be questioned individually, the court does not anticipate that the process will be very long with respect to any individual juror, so you are excused at this time. You may be seated, counsel. Then I will see you in the conference room near the judge's chambers in 10 minutes. I'm not going to take them all in order. We'll start with Mr. Slaby. Mr. Slaby, I think I indicated on the record the reason for our little session here. Because of the length of this trial, which is kind of unusual in the amount of media attention it's received, you probably have memorised by now the admonition I normally give at the end of the week. And we just want to give each juror an opportunity to let us know if there have been any problems. If they have been exposed to any information from any source whatsoever about the case that you know might have effect on the juror. So is there anything you feel the court should know?
I don't believe so.
You feel you have been able to follow the instructions okay?
Yes.
Alright. Can you tell me you have heard other persons, whether they be jurors or otherwise, say anything about the case?
No, not about the case.
Okay.
I'm
sure there's been talk among the jurors. We've heard it sometimes as you leave.
I don't think there's been anything improper.
Alright, very well. I'm going to excuse you then. The sheriff will escort you back to the jury room.
If we're going to continue this, we should see if Mr. Avery is willing to waive his presence. We have got the sheriff walking these people in. We have got 2 armed law enforcement officers right outside the door, and we've got a 4th one right in here. It just has a feeling of, an encampment. I don't think anybody would assume that they are worried about Norm Gahn.
I'm worried. He is right behind me.
Well, there's only one sheriff person in the room, and I think, at defence counsel request, I deliberately kept them stationed behind the juror.
If he was going to be here at all, that's right. But the sheriff is walking them in, and there are 2 armed, in uniform, officers right outside the door.
Could they be out of that door?
There's another one out there. That's 5.
Let's do this. After this next juror, we'll take it up and we'll ask the sheriff to return.
Okay, sure.
Hi.
Hi.
Have a seat.
Is this the hot seat?
That's the hot seat. I told you the room wouldn't be very big.
Yup.
As I explained late Friday and this morning, because of the length of this trial and the publicity that it's received, now as we're getting toward the final stages, we just want to make sure that there haven't been any problems with the jurors being exposed to information they shouldn't be.
Mm-hmm.
So what I'm primarily looking for is, do you feel that you have been exposed to anything that you shouldn't have been?
My night ends at 8:30 at night. I'm too much running with the kids, tournaments and everything.
So you have been busy and you don't feel there's anything you have been exposed to?
No.
Let me ask this. Has there been, I know the jurors talk to each other, But has there been any discussion about anything involving the case that you're aware of?
No,
There's not been?
no.
Okay, very well, thank you. At this time, we're back on the record. The sheriff is in the conference room. The jurors outside the conference room. The defence counsel, I think, expressed concern about the jurors seeing the sheriff's deputies as they came into the room. It's not a problem with the deputy in the room, as I understand it, but the defence was asking if the deputies outside could what?
Not be there. I mean, that's, I'm just concerned about doing this in a way that
Okay,
has as heavy a law enforcement presence as we have got here.
what about if they sat in the outer conference room? Behind the wall that's behind...
That was a jailer and state patrol. We could dismiss the state patrol officer.
If they're sitting out there, no one's going to see them.
I think Brett Bow is already out there.
Can I just ask, in this room, why we're not using a stun belt?
That's been ruled on already.
That's been ruled on in a court proceeding, not in a conference room, Judge.
I think the concern about what could happen with the stun belt remains the same. I'm not going to revisit that. There has not been any problems with the defendant throughout this trial. I see no reason to revisit it. But security-wise, Sheriff, I guess the question is, does that work for you?
Sure. If I could just be standing out here after I bring the juror in?
Right.
Okay.
You can stay out there. I think they're asking, and the deputies, if you like them nearby for security, that's fine.
Okay.
Have them sit in the outer office rather than standing by the door. Am I correct?
Yeah, and if that doesn't work, we will talk about waiving his presence, so to speak.
Okay. For what it's worth, I should note that when I saw the first juror come in, and the kind of surprised look on his face on the way out of this room, I didn't get the impression it was due to a couple of deputies outside so much as all of us sitting in the room, with just one chair left for him. That was my impression. But at any rate, Sheriff, if that works for you, you can have your deputies sit down in the outer office. Take Miss Dorn back, let's bring in Miss Mahler, Richard Mahler.
Okay.
Do you have a particular order in your head?
No, I'm trying to go as random as I can.
There was much less physical fidgeting with this juror.
She saw the other one come in back, so...
Right. Some stranger wasn't sent in to pick up his coat.
She always has a little more effervescent in court. The other guy wasn't quite so talkative.
Good morning, Mr. Mahler.
Good morning.
Well, there's no secret why you're here. I indicated in the courtroom.
Right.
Because of the fact that the trial has gone on for 6 weeks and there's been a fair amount of publicity about the trial, I have given the jurors warnings at the end of every day and admonishments not to watch the news media. We just want to make sure that none of the jurors have been exposed to information that they shouldn't have been seeing.
Okay.
And so at this time, I'm just asking, is there anything that you feel you have been exposed to that could impact your service as a juror?
No. In the beginning, my wife said that Channel 12 humiliated me and my family on TV, but that was about it. That has no effect on what I'm doing here.
I don't think they would have been permitted to identify a juror.
Well, they didn't say my name, but my wife said she knew who I was because they said a musician living on the wife's trust fund, which kind of pissed her off, so she wants nothing to do with it.
Channel 12 is in Milwaukee?
Yes.
Hopefully people in Milwaukee didn't know, but do you feel that that would have any impact on your ability to be fair in this case?
No, I'm here to take in the evidence and weigh it out.
Okay. Have you heard any discussion of the case by any of the jurors or anything else about the case?
Nobody has said anything.
Okay, all right, good. Thank you. You may step outside. The sheriff will take you back. All right. How about Mr. Wardman? Good morning, Mr. Wardman. As I indicated on the record, we're having this session just because the trial that's gone on for 6 weeks. There's been a lot of publicity about it, and for the benefit of the court and the parties, and to make sure that there is a fair trial, we're just double-checking to see if any of the jurors have been exposed to any information about the case that would affect their ability to serve as a juror. Can you tell us if you feel you have been?
No, last night is the only night I seen it on TV and I had clicked it really quick.
You turned it off right away?
Yeah, after I was watching No Deal or No Deal, I was surprised they put you on there in the commercial time.
They tell me I've been on there more than I should be. Okay, so, but that was it, and you turned it off right away?
Yeah, and I don't get that paper, so...
And the second question, to the best of your knowledge, has there been any discussion about the case by any of the jurors?
No.
No, okay, thank you. You can step outside. The sheriff will take you back. And let's try, if the sheriff can duck in here for a minute. Sheriff, Diane Free, number 2. Good morning, Miss Free.
Good morning.
As I indicated in the courtroom, the reason we're doing this is because the trial has gone on for, 5 weeks now, and there's been a good deal of publicity about the case. So just to make sure that both sides get a fair trial, we're double checking to see if any of the jurors may have been exposed to any information about the case that you feel could impact your ability to serve as a juror. Have you been exposed to any information about the case?
No, I missed the news though.
You're not that many days away. And the second question I have is, are you aware of any conversations that have taken place amongst any of the jurors involved in the case?
No, we have done really good policing ourselves.
Okay, I'm glad to hear that. All right, thank you. That's all I have. You are excused.
Thanks.
Number 7, Paul Nelesen. Good morning, Mr. Nelesen.
Good morning.
First of all, how are you feeling today?
Fair to partly cloudy, I guess.
Better than last week?
Yeah, a little bit better.
As I indicated on the record, because of the fact that the trial has gone on for 6 weeks and has been the subject of a lot of publicity, as we get towards the end stages of the trial here, I'm just trying to make sure that there haven't been any problems of that nature.
Sure.
I addressed, so my question is whether you have been exposed to any information, whether anybody tried to talk to you or anything that information about the case that could affect your ability as a juror.
No, I've had people ask me, but I pretty much tell them what you had told me. No, I can't talk about it. Everyone pretty much just drops it.
Okay, that's good to hear. And the second and final question is, are you aware of any discussion that's taken place amongst any of the jurors about the case?
No, we're usually keep pretty quiet.
Okay, alright, that's good. You're excused.
That's it? Okay.
That wasn't so bad?
No.
Let's do number 8, Nathan Klein. Good morning, Mr. Klein.
Good morning.
As I indicated on the record, because of the fact the trial has gone on for 6 weeks and has been subject to a lot of publicity, and the trial is starting to wind down and we're getting near the end, we're taking the opportunity to make sure that the jurors haven't been exposed to anything that they shouldn't have been. So my first question would be, have you inadvertently or otherwise heard anything on the news or had persons talk to you or anything else?
No.
About the case?
No, I have been very good about it. Immediate family, nor nobody else in the group.
And I did get your note about the propane delivery driver. As I understand it, that was one of the witnesses from a few days ago?
Correct.
You indicated that you spoke to him 2 or 3 years ago when your propane tank.
Yeah.
Did you just talk about the propane?
Yes, there was nothing more, but I felt that I should let you guys know.
Is that the extent of your acquaintance with him?
Yeah.
You don't think that would impair?
I don't know the guy, he doesn't hardly know me.
Last question is, are you aware of any discussion that's taken place about the case by any other members of the jury?
No. No, I feel like we have a really good grip in this. Everybody is diligent about not speaking of anything.
Okay, very good. Thank you.
Yeah, thanks.
How about number 12, William Mohr? Good morning, Mr. Mohr.
Good morning.
As I indicated on the record, because of the fact that the trial has gone on for 6 weeks and it's been the subject of a good deal of publicity, we're just questioning the jurors to make sure that they haven't been exposed to anything that could jeopardise the right of either side to a fair trial. So my first question is whether, inadvertently or otherwise, you have heard anything on the news or other persons have talked to you or tried to talk to you about the case?
No.
Anything?
No.
Thanks. And the second question I have is, Are you aware of any conversations that have taken place amongst any members of the jury that were related to the case or about the case?
No.
Okay, very good. You may stand up and you will be escorted back.
Alrighty.
Number 3, Temme. Good morning.
Good morning.
Have a seat.
Okay.
As I indicated on the record, because of the fact the trial has gone on for 5 weeks now and has been subject of a good deal of publicity, we're just taking this opportunity as we near the end of the trial to make sure that, inadvertently or otherwise, none of the jurors have been exposed to any information about the case that they shouldn't be. So my first question is, has there been anything on the news or any person who has tried to talk to you or anything else with information about the trial?
No.
Okay, and my second question is, are you aware, have you heard of any discussions by any other members of the jury about the case?
Oh, no.
Okay, thank you. That's it. Let's try Barbara Schmidt. Number 4. Good morning. Good morning, Miss Schmidt. As you know, the trial has been going on. We're in the 5th week now. And because of the fact of the length of the trial and the amount of publicity that it's received, it's very important to both sides that the trial is heard by a fair and impartial jury. And we want to make sure that whether through inadvertence or otherwise, or for any other reason, that none of the jurors have been exposed to any information that could affect their ability to serve as a juror. So, I have a few questions for you. Have you heard anything about the case from any of the media during the trial?
Nein, sir!
The other thing that we asked about, and I know that's something, through inadvertence or through no fault of the jurors, it can happen, but have any other persons attempted to talk to you about the trial, whether other jurors or family members or anything else?
Nein!
Okay. Is there anybody else that lives in your household with you?
Well, my husband, my 3 sons.
Okay. Are your 3 sons home during the day?
Mostly, the older one is a foreman at EVM, and the other 2 go to school.
Okay. Have either any of your children or your husband said anything to you about the trial during the course of the trial?
They mention things, but I just kind of ignore them.
Okay. Who would mention things?
Mostly my husband. I think he knows more about what's going on than I do.
Can you tell me some of the types of things he might mention?
Well, Saturday he said something to the effect that it didn't make any difference what the jurors would decide because everyone would go to appeals and all that kind of stuff. So that's basically it.
Do you know where he's gotten whatever information he has about the trial?
I don't know. He goes out to the greenhouse, which is our part business. And I imagine he got a radio out there.
Has he said anything to you that in any way is for or against one of the parties to the trial?
Nein, sir!
Okay, so he's mentioned things to you about the trial, but he hasn't said anything about, for example, how he feels?
Nein, sir!
Okay, and what have you done when he's talked to you about the trial?
Well, on Saturday, I went down to carry in wood. See, we have a wood burner in our basement, so that's what I do in my spare time. Carry in, putting in, carry in, putting in. That kind of stuff.
So you have walked away then when he's talked about it?
Yeah, it kind of perturbed him, but I did walk away. Yes!
And he is aware of the restrictions that the court has placed on you, that you are not supposed to talk about it?
He's aware, but he likes to see if he can get my goat, so to speak.
Okay. Has he attempted to provide you with any information outside of what the jury has heard in the court about this case?
Nein, sir!
Okay.
That he won't do. But I do have a problem with those little, I don't know what you call them, tickers across the bottom of the screen. I usually pay attention because it means something has happened. Or like the kids don't have to go to school that day.
Sure.
Because of bad storms. That kind of bothers once in a while if I don't catch it in time.
So, what do you do if you see a ticker that involves the trial?
Well, I have been engrossed pretty much in books and stuff. I don't pay too much attention to TV. But when this little sign goes off, and then all of a sudden the ticker flies across, well, you kind of pay attention to it.
Okay.
But then it involves the trial or something like that, I turn it off quick.
Okay, alright. So do you feel that you have been exposed to any information that would affect you or your ability to be fair as a juror?
Not that I know of.
Okay, have you talked to any other jurors about what you just talked to me about?
Nine, sir.
Do you know if any other jurors have talked to you, or have you heard anything about similar situations where somebody in their family might be talking to them?
Nine, sir. I kind of sit back in the room and read all day. And they go around talking.
Okay.
And I kind of absorb bits and pieces here and there, but...
Has any other juror said anything to you on the bus about them talking to their spouse or anything?
Not they talking to their spouse. No, nine.
Talking to anybody about the case?
Not about the case. About the measures as not hearing it. You know, like turning off the radio.
Okay.
Or listening to the PF. Whatever. Public service thing. You know.
Okay.
I don't know what that's called. PBS.
So based on what you know, you feel that the other jurors are doing their best not to hear anything about the case?
That's right. That's
All
right.
All right. I'm going to have you... Why don't you just step outside for a second with the sheriff there?
Excuse me?
Let's just hold for a second. Shut the door.
Okay.
The only thought I had is that you might want to ask her what she's learned from the tickers.
If she learned anything that wasn't in the trial.
Depending on what she reveals, whether you go further is entirely dependent on that answer. The tickers, I wouldn't even want to bring her back for that.
It's kind of hard to believe that as to how many times that her husband has said anything and if he is trying to get her goat all the time. But I'm not sure what would provoke that thing. Doesn't matter what the jurors are going to do. Everybody is going to appeal.
Yeah, well, that can be a situation where a spouse, if they know they are not supposed to be talking about the case, can tease them without saying anything that would prejudice the juror.
Let's ask her what her husband thinks about the case.
More open-ended. What does he think about the case? He knows more about it, what's going on, than I do. How can that be?
Sure. Anything else before we bring her back in? I will ask her both. I'll ask her about the tickers. Miss Schmidt, I have just a couple of follow-up questions. One was about the tickers you mentioned. Do you know, before you were able to turn the TV off or look away, do you remember anything that you saw on the tickers?
Not particularly. 9. It mentioned you and something about Mr. Avery. And then I don't have any idea. But see, like the something is, it goes, like I said, it goes in one ear and out the other. And sometimes it doesn't register in between.
So, whatever you saw on the tickers, you can't remember?
9, sir.
The other question I have is, with respect to your husband, do you know what his opinion is about the case? Does he think...
He has strong opinions. They don't always agree with mine.
Okay, but what opinions of his has he given you?
Just what he mentioned about no matter what happens to the trial, you are going to have appeals and all kinds of stuff anyway, so...
Has he told you anything about whether he thinks the defendant is guilty or innocent?
9!
He has not?
9!
When you say he has strong feelings, What are those strong feelings that he passed on to you?
Not anything regarding the trial, but like home things. Like if the boys have trouble with this or that, they know better. They're supposed to do this and they're supposed to do that. He doesn't holler at them or scold them. It's always up to me to do the punishing.
How often has your husband attempted to talk to you about the case?
Well, twice for sure. As long as this has been going on, maybe twice.
Over the 5 weeks?
Yes, sir!
Do you remember which, about when they were?
9. I couldn't tell you on it.
Do you remember the most recent one?
Just this Saturday. This past Saturday.
This past Saturday?
Yeah.
And the other one would have been about how long before that?
Probably when it just started.
Nothing other than that?
9, sir!
Alright, thank you. You may step outside. Just hold it for a second and shut the door.
I think we need to hear from the reporter next. We're kind of shooting in a vacuum.
Do you have any questions for this juror at this time?
On the thing, as a result of that family dynamic, you think that's going to have any problem for you?
I'm sorry, you're going to have to talk a little louder.
Oh, okay. I'm sorry. The only thought I had, I'm not saying you definitely need to ask it, but the only question I had is, do you think as a result of the family dynamics here that you would still be able to fulfill your role or duty as a juror in this case, or something to that effect? Other than that, I don't really see anything else.
I think I asked her something like that earlier, but it's a good idea to ask her again. Now that we've heard everything, let's bring her back for that one question. One more question.
All right.
Miss Schmidt, you'll be relieved to know I only have one more question. As a result of whatever discussion you had with your husband on those 2 occasions when he tried to talk to you about it, do you feel that anything he said would affect his ability to be fair and just and base your decision on the evidence in this case?
9, sir!
Okay, thank you.
This is it? This time? Right?
I promise you're not coming back. Nancy Stents.
As a matter of demeanour and watching her, listening to the answers, I don't believe her. I don't think this is a candid juror.
Good morning.
Good morning.
Have a seat, Mr. Stienmetz. Have a seat, Miss Stienmetz. We're bringing all the jurors in this morning to ask some questions because of the length of the trial and the amount of publicity that it's had, just to make sure that all the jurors can be fair and impartial. You know that although there's been a reporter sitting behind you, they are prohibited from identifying any jurors by name. And I told him also by sex. So any reporting as a result of what happens here cannot in any way identify anything that is said by any particular juror.
Okay.
The first thing that I want to ask is that the trial has gone on for 5 weeks now, and it's received a great deal of publicity. So we're calling in each of the jurors in order to find out whether any juror may have, through inadvertence or anything else, been exposed to any information about the case from the news media, other person, or any other source that you can remember. Have you been exposed to any such information?
I have been exposed to, I have not seen a thing on TV. Absolutely nothing media-wise. I have just been exposed to some chit-chat that I've heard, but that's...
Chit-chat from who?
Some of the other jurors.
Okay. Are you referring to the information you provided the court earlier?
Yeah.
Okay, and we have heard something about that as well from one of the participants. I'm going to ask you, if you will, at this time, to tell me, as best as you can remember, the circumstances and what happened.
From the whole perspective of what I've heard?
Yes.
Since the beginning of everything?
Yes. My understanding, it involves 2 other jurors.
Correct. From what I had heard. The first week, first couple of days, Augie, he sits right next to me, made the comment that when he got...
That's next to you on the bus?
No, he sits next to me at our long table in the room.
Oh, not in the courtroom though?
No.
Okay.
No, in that sitting room.
Okay.
So, there's always conversation. Everyone is laughing and having a pretty good time, generally speaking. But the first week, he made a couple comments that when he would get home, that his wife watches the trial while he's in there, and that she would tell him what transpired when we would be sent out of the courtroom. And one of the other jurors went, shh, shh. You're not supposed to be talking about that. You're not supposed to do that, And then he was quiet. And then a couple of days later, again, he started saying that. And he got shooed by several people. And oh, man, I don't like having to do this. And then that was like the first week. Then you had said that you were going to be giving a CD to keep everyone's temptation. So I think that was like on a Friday. And about a few days after that, beginning of next week, it was conversation about how nice it was and that, no one should be tempted now or whatever. And then there was conversation, just everybody generally here and there popping in something. And they were saying how you were not supposed to, because you were doing this. We're not supposed to be watching TV, reading newspapers, the computer and stuff like that. And then computer talk started, and Augie, he tends to want to. I know we're not supposed to talk about it, but he wants to try to start a conversation, and he gets shooed. But then when we were on the computer stuff, saying, well, you can pull stuff up. And I had said, I think what started that was I had said, well, I had a girlfriend who said that we were all in the computer with our occupations, our family. And I was kind of worried about it because I didn't want anybody to know who I was. I think that's how the computer started. And then Augie, he was saying, well, how can you erase something on the computer to have it off the C drive, I believe. And they were telling him, but then they said, well, once you delete it, it's still in the memory, etched in the computer, and anyone can still pull that information out if they want to. It was just speculation on my part. It just was all very coincidental, and he got like whiter than a ghost and didn't say a word the rest of the day. So that was just circumstantial. But I mean, it put a flag in my mind, and I'm thinking, well, should I say something or not? So I didn't, thinking that was the end of it. Then I guess what made me think, well, I better say something, was then Wednesday on the bus, him and Barb were sitting together, and Barb is very quiet. And she was talking about all her things going on at home, on the farm and stuff. And I heard Augie mention again about his wife watching it and wanting to tell him what happened. And Barb said that her husband watches it too during the day, but he tries to pressure her, influence her with his opinions. She wouldn't mind she doesn't mind him watching it, but he pressures her with his opinions. And then they were talking, I don't know, I heard bits and pieces about when news flashes pop up on the screen with film flashes. Augie was saying that it's hard to get up and leave. I don't know if he said he does or doesn't, but that when they pop up, because they pop up frequently, it's difficult. And that's when I heard Barb specifically say that she sees when the ticker tape goes across the bottom of the screen, even though there's a program on, that she does read the ticker tape, that she doesn't leave the room. And that's when I sat on it for a couple days, and I thought, well, I better say something.
Sure. Let me ask you just a few follow-up questions. First of all, that represents the extent of exposure you had, right?
Yes.
As I understand what you are saying.
Yeah.
From what you reported that Augie said, did you get the impression that, besides his wife watching what happens when the jurors leave the room, that she's passing that information on to him?
Yeah.
Do you have any reason to believe anybody else on the jury is getting that information?
From someone else?
Well, but if Augie is passing on what he knows to anybody else?
I don't think so. I mean, Augie, he didn't say, oh, this is what happened and this is what happened. But he just said, my wife tells me.
Okay.
When I had come home. A few times I've heard him say that.
Did he say if he makes any effort to stop her?
I did not hear that.
And with Barb, did you learn anything about what her husband's opinions are?
No.
So you don't know what they are?
No. All I heard was she said that her husband watches the court proceedings on TV too while she's in here, and that she doesn't mind except that he pressures her with his opinions about what goes on in the courtroom.
When you heard her say pressures her with his opinions?
Mm-hmm.
Were you sure that it was pressures her with his opinions about the case as opposed to pressures her with his opinions about other things?
I got the impression it was with the case because that's what they were talking about.
Okay, but she didn't say what those opinions were?
No, they did not. I have not heard any of them say what someone had told them other than that they had been told.
Okay.
Influenced or whatever, I don't know. So I'm sorry this has turned into a mess.
No reason to be sorry for being conscientious.
It's probably nothing, but if it is something and if I didn't say anything, it would be very difficult.
Believe me, everybody has to live with themselves and it's good to be conscientious.
So?
All right, I think that's all I have for you. I'm going to let the sheriff take you back.
Give me a minute to... I blush very easily.
Miss Jynx.
Yes?
When you leave with the sheriff, you can tell them if you want to sit down outside for a little while, you can go in my office if you want.
They've already made a comment that Barb was out so long and I'm out as long as she, and I don't want them to get any ideas.
At any rate, you take whatever time you need and we'll have the sheriff take you back.
Okay.
Thank you. Let's try 16. Laura Barber.
We may want to ask this next juror a little more pointed questions about, how you police yourselves. If she says that nobody is talking about it, does it come up at all? What do you say, or how does it get, or sounds like something that's happened more than once?
Might want to keep her a longer time.
Right. I knew there were going to wonder because Barb was back here longer.
I was wondering that too.
Good morning again.
Good morning.
As I indicated on the record, because of the fact that the trial has gone on for a number of weeks and because it's gotten a lot of publicity, and now as we're getting towards the end of the trial, we're taking time to make sure that none of the jurors have been exposed to anything they shouldn't be. So my first question for you would be, can you think of any information from the news media or any persons who said or tried to say anything to you? Has anything about the case been presented to you?
Not at all, not at all. In fact, if I can just speak, my family, once they knew I was going to be on this jury, as soon as anything comes up, they mute it. It's...
Okay.
And I then avoid all visual contact with the television. When it's over, they will say it's over and put it back on. People I work with even avoid saying. They will come up and say, glad to see you're still working here. I work one day a week, and that's the extent. They don't care anything else, and I appreciate that. I haven't picked up a newspaper. I don't even go through the sale papers on a Sunday anymore.
Okay.
Just in case.
That's good to know. Next, I'm wondering, and we're asking all the jurors about this, have you heard any discussion about the case during the course of the trial from any other jurors?
No, we make it specific that we don't talk about the case. We may talk about some of the people.
Okay.
But that's usually it, and humorous. In fact, I have never been with a group this long, this close, that everyone gets along so well.
Okay.
It's sometimes rather humorous.
Sure.
And I appreciate that, because the time goes a lot nicer.
Okay. Have any members of the jury had to kind of hush up any other ones before they started talking about the case, or?
Someone might have started to say something, and it's like, whoa, hold it, that's it. And it's quiet.
Okay, so there's pretty good policing?
Very much, very much. Everybody keeps track of everybody else, unless they're talking to themselves in the bathroom, But to me, that's...
And you haven't heard?
I'm sorry?
And you haven't heard anything come from any of the jurors in this case?
No, not at all.
All right, thank you.
Oh, darn. I was kind of enjoying this.
Well, it's a break from the norm.
Definitely. Actually, we just discussing we missed our morning break. Is it okay if we have one?
It's going to be running all together.
I'm telling you, that is why it's such an enjoyable group. Because this is one of the things we're worried about, our break.
Well, that is good.
Thanks.
Let's try Marion Flint.
We don't talk about the trial, but we talk about the people.
Talking to themselves in the bathroom? I didn't know that any of you guys wanted me to pursue that. I didn't know if they meant other jurors or the participants in the trial. Marion Flint is the next one. Good morning, have a seat.
Good morning. Okay.
We saved you the only chair that's left. This is, as I explained on the record, because of the fact the trial has gone on for a number of weeks, it's gotten a lot of publicity. We're getting near the final stages of the trial, and because of the length of the trial and the publicity, we're taking this opportunity to talk to each of the jurors just to make sure that the jurors haven't heard anything inadvertently or otherwise that could impact their ability to serve. So, my first question is, are you aware of any information that you have been exposed to, by accident or otherwise, on the news, or from other persons or any other member of a jury, anything about the case?
No.
You have been able to...
I live alone.
Okay.
So I can monitor myself.
Sounds like you are doing a good job. Next question is, I know the jurors have been together a lot about this case. Are you aware of any instances that came to your attention in which any of the other jurors said anything about this case?
None. They have been really good.
Okay, alright. Well, that's good to hear. I think that's all I've got for you.
Okay, thank you.
Mr. Schuette, good morning.
Good morning.
We're here, as I indicated on the record, in recognition of the fact that the trial has gone on for 5 weeks now, and it's been the subject of a good deal of publicity. And now that we're starting to get near the end of the trial, we wanted to make sure that all the jurors haven't been exposed, or that none of the jurors have been exposed to any information through inadvertence or otherwise about the trial, because of the importance to both parties to get an absolutely fair trial. And we are especially doing it because we understand, even if the parties try to avoid information, it's not always easy to do that. So, in that light, I would like to ask you a couple of questions. First of all, whether or not you have been exposed directly to any media reporting about the case during the course of the trial.
No, I have not.
The next question I have relates to the information gained from other parties or other persons, whether there's been any personal acquaintances, other jurors, or, I know in special cases, members of the person's family, whether any such information or any persons have attempted to talk to you about the case in any way.
No, nobody has. No, there have not.
Have there been any other conversations involving other members of a jury about the case?
Not at all, no.
Okay. There, in cases with people that have spouses, especially, we're asking the question, do you have a spouse at home?
Yes, I do.
Has there been any decision whatsoever between you and your wife about the case? Is she following the case in any way?
She is limitedly following it. We have no discussion that would be involved. I think the only thing about the whole procedure is what we have for lunch.
Okay.
So there hasn't been anything as far as any details as far as the trial itself.
Okay. Has she been following the trial in any sense at home, on the internet?
Well, somewhat. I think a little bit in the newspapers, not on the internet. She doesn't know how to get on the internet. Limitedly on the radio. I don't think the radio, just limitedly.
And you said she hasn't talked to you about the facts of the case. Has she said anything to you about the case during the course of the trial?
No, not that I can remember. I pretty much told her, let's not talk about it. She may well talk about it to some of her family members, but she doesn't relate that to me.
Are you aware of any discussions that have been had between any members of the jury about the case during the course of the trial?
Not at all, no. I think the jury, in my observation, I think they have been very observant of your request not to talk about anything.
Have any of the jurors had to be told to stop talking about the case by any other jurors?
Not that I can recall.
Okay. Has anybody given any information to you about what was happening during the trial while the jurors were outside of the courtroom?
No.
Thank you. I think that's all I have. The sheriff will take you back.
Thank you.
And Miss Thorne will be next. Good morning.
Good morning.
By the look of the draw, you are the last person.
Yeah, I get to wait the longest and sit and wonder.
As I indicated on the record, this trial is different than most in a number of ways, and one of the reasons is it's gone on for 5 weeks now. It's been subject of a good deal of publicity, and as we now get near the end of the trial, because of the length of it and the publicity, we're interviewing each of the jurors to make sure that they haven't been exposed through inadvertence, no fault of their own, or any other reason, deliberate or not, to any information about the case.
Okay.
So, the first question I have for you is whether, during the course of a trial, through the news media, family members, employers, members of the public, anyone you have received any information about the case during the trial?
No.
Okay. I'm trying to remember where you are employed again.
Waitress, but I'm off the schedule until I go back.
Oh, so you haven't been off the schedule?
Ever since it started.
Do you remember the last time you worked there?
The Sunday right before we started.
Before the trial started?
Yeah.
So it was after the jury selection, but before the trial started?
Right.
And you haven't worked since then?
No.
Okay. Do any family members of anyone live with you at that home?
My fiance.
Has he attempted to talk to you about the case?
No,
Have any fellow employees, members of the public, anyone else talked about it?
No.
And are you aware as to whether or not there's been any discussion by any of the other jurors about the case?
No,
No one has tried to talk to you?
No.
And you haven't heard anyone else?
No.
Okay, alright. I think that's all I have.
Okay.
You can step outside with the sheriff.
All that wondering for nothing, huh?
We were trying to get you some exercise this morning.
Okay.
Alright. Counsel, what I'm going to do at this time is adjourn for a break. I will give you the chance to look at your notes and digest things. And I have 11:22 right now. About 20 minutes to 12. Report to chambers.
This isn't something we'll do on the record?
We'll determine.
Oh, I see what you're saying.
What's the next step after that?
Okay.
At this time, we're back on the record outside the presence of the jurors. All counsel and defendants are present. Mr. Strang, does the defence have any additional evidence it wishes to present?
We do not, Your Honour. We intend to rest formally before the jury next joins us in the courtroom.
Very well. Before we bring the jurors in the courtroom to inform them that the defendant in this case has a right to testify if he wishes, and the court wants to make sure that if he is declining to exercise that right, that it is done so knowingly and voluntarily. Mr. Strang, have you raised this issue with your client?
I have raised it with Mr. Avery. That is, Mr. Buting and I both have, jointly, several times, probably beginning before trial and then during the trial.
Thank you. You can move the microphone over to Mr. Avery then. Mr. Avery, do you understand that you have a constitutional right to testify in this case if you wish?
Yes, I do.
And do you further understand that you have a constitutional right not to testify if you wish?
Yes, I do.
Do you understand that the decision whether to testify or not is yours to make?
Yes.
That means you can listen to your attorneys and listen to their advice, but ultimately, it's your call. Do you understand that?
Yes, I do.
Has anyone made any threats or promises to influence your decision?
No, they didn't.
Have you thoroughly discussed your decision with your attorneys?
Yes, I did.
And have you made a decision as to whether or not you wish to testify in this case?
Yes.
What is your decision?
My decision is, I'm an innocent man, and there is no reason for me to testify. Everybody knows I'm innocent.
Okay. So you wish not to testify, is that correct?
Yes.
Thank you. You may be seated.
Thank you.
Mr. Strang and Mr. Buting, have each of you had sufficient opportunity to thoroughly discuss the case and a decision whether or not to testify with your client?
Yes, we both have.
And are each of you satisfied that he's making his decision not to testify knowingly, intelligently, and voluntarily?
Yes.
Very well. The court finds that Mr. Avery's decision not to testify in this case is knowingly and voluntarily made. I am satisfied he is aware of his constitutional right to testify. If he wishes, and he is knowingly and voluntarily declining the right to exercise the right to testify, is there anything else that either party wishes to address before we bring the jurors in?
There is. From the defence, Your Honour, I cannot remember when, but sometime earlier in this trial, we discussed the issue of one of our jurors' participation on an earlier civil jury in which the witness here was a party. I will not name the juror, but the juror is known to the court and to opposing counsel. We argued at the time that although this was uncharted territory, as a matter of case law, that the juror, having once passed on the credibility of a witness here and that witness' role as a party in a prior civil lawsuit, we thought would leave a strong enough impression on a juror and enough commitment to conclusions about credibility that there would be at least objective bias, if not also subjective bias, and reason to relieve the juror from further responsibilities. The court disagreed. We went back to the case file in the earlier civil case and had our defence investigator look at that file in the Manitowoc County Circuit Court. And it appears from our investigator's review that the real crux of the dispute was that to be resolved by that earlier civil jury was whether the man who was a witness here and the plaintiff in that earlier case was malingering or not. So his credibility, as we understand that earlier file, was not only an issue, but probably the main fighting issue, the main point of dispute in the earlier case. Clearly, given the jury's award of something better than $170,000 to the plaintiff, that credibility contest was resolved in favour of the plaintiff there, witness here. What we would like and ask the courts to do is to transfer the whole of the file from the earlier case to Your Honour's custody now, so that Your Honour might review both the clerk's minutes and such trial transcripts as there are. The parties also should have an opportunity to review those. I have no reason to think that opposing counsel have seen the file, and I know that neither Mr. Buting or I, personally, had seen the file. We simply delegated this to an investigator to take a first pass through that earlier file. So I request that the court bring the file physically to Chiltern from Manitowoc, review the file itself, allow the parties an opportunity to do that, and we anticipate renewing our motion to relieve this juror from further responsibility in this case, acknowledging, as we have from the beginning, that the juror did the right thing by raising the issue at all with the court. So this isn't a juror misconduct issue, claim, not even remotely. We think it's an interesting, as far as we know, unprecedented factual situation that arises that we believe does require that the juror be relieved. So that's the request I'm making today and the one I'm forecasting later.
Let me ask one question before I ask the state if they wish to comment, just to enable me to prepare to re-evaluate your request. Is it the defence position that even if the juror is not subjectively biased, that by virtue of the juror's participation in the prior trial, that the juror is objectively biased?
Yes, in a word. And I won't labour again to the arguments I made earlier, but I spoke to the court at the time about the unique function of being a judge of facts and the stylised way in which judges of facts, namely jurors, assess the credibility of witnesses, and that it's very different than the way we assess credibility day to day, or in the grocery store or barber shop, or wherever we may have conversation with people. And having undertaken that very special and stylized credibility assessment, I think it's unlikely that a juror would reconsider the credibility assessment once arrived at as a matter of judgment, as a judge of the facts, and that, objectively, this looks like someone who comes in with an opinion on the credibility of a witness that has been cast by a very special prior intense experience with a heavy responsibility for weighing credibility in that earlier role, and now being asked to do so again under the same pattern instruction and with the same special and stylized considerations that apply in a trial to the judges of the facts who fill out the array of 12 people in a jury box. We don't think, reasonably, she could be expected entirely to set aside that prior, not just experience with the witness, but conclusions about credibility that she endorsed and drew after deliberations with a group of 12 in that case, and affirmed with her verdict.
All right. I take it at this point the defence is not asking to argue the merits of its request, but rather simply asking the court to have the file transmitted here tomorrow.
Well, that is correct. I argued the merits earlier. I anticipate I will argue the merits again, but for today, if we can get the file and all counsel can have whatever opportunity they wish to avail themselves of to look at the file, we'll be in a better position to discuss the issue on the merits tomorrow or at the court's convenience.
Anything else from the state?
I would simply say that we don't oppose that suggestion and would certainly like the court to examine the file at its leisure. I will no doubt be heard tomorrow regarding any renewed motion for the recusal of the juror. I will save my argument until then.
Very well. The court will make sure the file is here tomorrow. I don't know how much leisure time I will have to review it, but I will make sure that it does get reviewed. Anything else before we bring the jurors back in? All right, you may bring the jury in at this time. You may be seated. Mr. Strang, at this time the defence may call its next witness.
Your Honour, Mr. Buting and I jointly have elected to rest at this time on behalf of Stephen Avery.
Thank you. Mr. Kratz, does the state have any witnesses or testimony to offer in rebuttal?
We do not, Your Honour.
All right, members of the jury, that concludes the evidence portion of this trial. I have a couple of notices to read to you. I can tell you that the parties informed me earlier today that they expected the evidence to end sometime early this afternoon. They have also requested that they have tomorrow to prepare closing arguments and address some other matters that must be addressed before we have the jury instructions and closing arguments of the parties, and I have granted that request. I'm going to, at this time, excuse you for the rest of the day and also notify you that you won't have to report to court tomorrow. You should report at the normal time on Wednesday morning, and when you get here, you will then proceed with the final jury instructions and also closing arguments of the parties. I do have a few notices to read to you before I excuse you for the day. As you know, the court's decision not to sequester the jury during the trial is dependent on the jurors not listening to, watching or reading any news accounts of the case, nor discussing it with anyone, including members of your family or other jurors. For these reasons, it is vital that you do not listen to any conversations about the case, do not read any newspaper or internet reports, or listen to any news reports on the radio or television about the trial. To assure that you are not exposed to improper media coverage, the court has ordered that, for the duration of the trial, that you do not watch the local news on television, nor listen to the news on radio, nor read any newspaper accounts, unless you first have someone remove any articles about this case from the newspaper. In addition, do not visit any internet websites or weblogs, which may include any information about the case. I should add at this point that although the evidence portion of the trial is complete, the court's order remains in effect. It is especially important at this time that you not be exposed to any information about the case. The court is asking that for those of you who are employed, that you not report to work tomorrow. I will make sure that you get paid a full day's jury pay even though we're not asking you to be here tomorrow because of the request that I'm making. Make sure that you do not disclose your status as a juror to anyone. If anyone attempts to discuss the case with you, politely but firmly notify them that you are prohibited from discussing the case. If you are involuntarily exposed to any information about the case from any source, take steps to immediately avoid any further exposure. Should you be exposed to any reports or communications from any source concerning the case during the trial, or should you become aware of anything that you believe may affect your ability to serve as a juror, you should not discuss your concerns with any jurors, but report any concerns to the jury bailiff. I have also prepared a memo which the jury bailiff will give to you before you leave today. There is a copy for each of you, as I think the parties disclosed during the jury selection process. It's difficult to predict how long jury deliberations may take. As disclosed in the memo, the court is requesting that you pack some luggage, overnight belongings, in the event deliberations go on for more than a day, and it's required that you stay over. If deliberations go on more than a day, we'll put you up in a hotel, make sure you get all your meals taken care of and everything else. There is further information in the memo that you will be receiving. With that, I'm going to excuse you for the day. You may be seated. Counsel, is there anything further either party wishes to put on the record at this time?
The defence moves now, at the close of all evidence, for a judgment dismissing, with prejudice, the remaining 3 counts of the second amended information. I ask the court, without further argument, to consider all of the evidence now received and to conclude that, even in the light most favourable to the state and drawing all reasonable inferences in the state's favour, the evidence is insufficient as to each one of the 3 counts to justify a reasonable jury concluding that the state has proven all essential elements as to each of those counts. And I acknowledge again that as to one of the counts, count 3, the felon in possession of a firearm count, we did stipulate to one element, so as to that element, the status as a convicted felon on the relevant date, there the evidence is sufficient because stipulated. But as to the other charges and their essential elements, I ask for judgment of dismissal for want of sufficient evidence.
Anything from the state?
Just that the actual legal standard the court is supposed to apply at this stage, not in the light most favorable to the state, but could a reasonable juror find guilt beyond a reasonable doubt? We do believe that that slightly higher standard has also been met regarding the 3 remaining counts. Would ask the court, without further argument, deny that motion.
For many of the reasons which the court gave this morning, the court believes that it has already had adequate opportunity to address this motion, and the court is going to deny the motion to dismiss the remaining 3 counts against the defendant at this time. Anything else before we adjourn this afternoon?
Yes, Mr. Buting was concerned that I was unclear, and I often am, as to the felon in possession count. I mean to concede only that one of the essential elements of that count is established, not concede that any of the other essential elements of that count are established. And second,
that's how I understood your argument.
Well, then, the court's become accustomed, perhaps unfortunately, to my clumsy way of speaking. I also had, before this trial started, I think on February 2nd, suggested that a mistrial may be warranted if, in fact, the state sought to proceed on the false imprisonment count and then fell short in its case in chief. That's what happened. I am not, at the moment, moving for a mistrial because I want to think long and hard about whether necessity for that really is manifest. And there's nothing happening with the jury now, so sequentially, if I wish to make that argument, I know that I could do it tomorrow, out of the jury's presence. So I'm not making that motion now, but I want to alert the court and counsel that the matter is fresh in my mind and under consideration.
Very well. If there's nothing further, we're adjourned for this afternoon.